first two units from Right to Fair Compensation and Transparency Act. Third one, Karnataka Land Revenue Act. Fourth one, Karnataka SC and ST Prohibition of Transfer of Certain Lands Act. And fifth one is RERA, which is becoming very much popular these days. Now, when you read RERA, right, after that you will see everywhere in news and all, you would be seeing RERA news only. Okay, so what RERA takes care of? Real estate project. Like many times there are builders, right? Builders would build a, like start with a project, real estate project, but they will not finish it on time. Okay, might be there would be some other complications whatsoever arises, right? There, this RERA is the like authority who regulates it. Okay, like real estate, whenever a builder says that, okay, you purchase this, like what happens in apartments before it's constructed, just when construction starts, everything gets sold out, right? And after that, builders delay often, right? In such cases, RERA is the body who regulates it. Okay, it would also see that whatever ads are published by the real estate, the promoter or the builder, those are also not misleading. All of that is taken care of by RERA. Okay, there are a lot of guidelines and all that stuff we have, like duties, functions, rights, and all that. This one is like an interesting topic, and these unit 1 and unit 2 are also interesting. Unit 3 and unit 4 you can see a little bit complicated, but yeah, it's otherwise something which you would see around you as well, not like some philosophical or theoretical subject. It's a practical paper that we have. Okay, so we'll start with unit 1 then.
Okay.
All right. So how do you study? Do you like try to memorize the answers, or you just try to understand and then in exam you write from?
Yes. I try to understand and write on my words.
Okay, good.
My
then.
own words.
Okay, all right, good then. So I have prepared. Okay, and what do you prefer, like question answer based notes or just like explanation kind of notes?
Sorry, ma'am.
Like, see this one, right? I have framed like questions from unit 1, whatever probable questions might be there, like that I have framed. So do you prefer this kind of note or explanation?
Yes,
on
ma'am. Yes, ma'am.
Question answer, right?
No, question answer.
Okay, fine.
But, I usually try to follow the repeated question.
Okay. So have you
From
downloaded
previous year
papers?
papers?
Okay.
Uh-huh.
For land laws, have you downloaded question papers?
Yes, ma'am.
Okay, maybe you can share that with me. I will try to add if anything is missing. I will try to add that. Okay.
Okay, sure, ma'am.
Yeah. All right. So this also gives us an idea on what kind of questions we might expect, right? Rather than simply following the syllabus. So this one is a question from a previous year paper only. Explain the history of land acquisition in India, because unit 1 and unit 2 are about how fairly land can be acquired without letting the people suffer, right? So we need to have an idea on the history as well. So history of land acquisition in India. So talking about land acquisition, so what does land acquisition mean in general?
For development purposes?
Yes.
Land is needed in a huge, I don't know how to explain.
Yeah, in a huge quantity.
Land is needed, and for those purposes, government have to acquire certain land.
Correct. So that means private property. Yeah. So private property, government can acquire for public purposes, right? Because as such, we cannot say completely no to developmental activities also. So that is also required. That's nothing but land acquisition. So land acquisition in India refers to the process of land acquisition by, it might be by central government, it may be by state government, or it may be by different departments as well, like National Highway Authority of India acquiring private property to construct or widen a certain highway. It might be the road authority, like the state road authority, who are acquiring in order to widen a certain, like a local road. Those things are very popular. So these are for various infrastructure projects or economic growth initiatives. Might be they want to set up an industry, might be they want to set up certain government department. All right, for them also it can be acquired. Several controversies have arisen with claims that landlords have not been adequately compensated. Now, when we talk about compensation being awarded to the person, there the problem arises because when for public purposes it is being acquired, as such you do not get the negotiation power, right? You cannot negotiate on the price that I want this much money, but rather there are some methods which are being applied in order to calculate how much you should be getting. Okay, and based on that people are compensated. If you feel that the compensation is too less, definitely you can file a case, but usually what happens is whatever prefixed method of calculation is there, based on that compensation would be provided. So that is what is leading to all the controversies, that landlords are not being fairly compensated when their private property is being acquired. When the government intends to carry out some developmental work like construction of dams, flyovers, bridges, mines, etc., it requires vast expense of land, like a lot of land they would require. Since land is a scarce resource, in order to carry out this work, government has to acquire land, thereby depriving the existing occupants from it. Whoever is residing there, they need to be removed from there, and this leads to large scale displacement and forced transfer of people from their land. If you are owner of the land, that's well and good. There are even some areas which are maybe government land only, but people are residing there for a very long time. Nobody never asked them to move away from there. They were residing there, maybe they have constructed house and all permanently settled there. All of a sudden government realizes that this is our land, we want to construct this, let's like let's ask those people to move. Might be within one night's notice they would be said that you need to vacate this plot. If you are not doing it, bulldozers and all they would bring, they would just break all the construction, they get displaced. Okay, so those kind of, have you heard of those things?
Yes, ma'am. Recently, a construction project is um, starting
Hmm.
in my area,
Hmm.
nearby my house.
Hmm.
Construction of bridge. So I heard that some people were against the project, and they had to finally they had to
Vacate.
vacate.
Correct. Right, so many
Uh,
times they protest also, but then it's of no use mainly, right? So this is not,
uh,
that's what the problem is, right? That they are displaced, and like within a very short notice everything happens, they don't get the time to properly rehabilitate or something also. So that's the issue over there. So history of land acquisition in India. Okay, the first land acquisition legislation in India was enacted by the British government in 1824, as in this process is continuing since before independence itself. This legislation was called the British Resolution 1 of 1824. So pre-independence legislations, usually we have these numbers. Okay, like post-independence, whatever we have, we still has these numbers, but we do not give that much importance to it. Like Indian Contract Act, you would see a certain number of this year, as in that certain year, this legislation was passed, maybe the fifth legislation, sixth legislation, like that, we have a number. We don't give that number that much priority these days, but pre-independence ones, we give importance to the number. Okay, so Bengal Resolution 1 of 1824, and this law applied to whole of Bengal province subject to presidency of Fort William. So entire Bengal province, it used to apply this legislation. And it enabled the government to obtain at a fair valuation land or other immovable property required for road, canals, or other public purposes. So it gave government the authority that if you want land or any immovable property, you can acquire that. When we say immovable property, it might be like a river or a lake or something like that also. In 1850, the British expanded the regulation to Calcutta as well through another legislation, the Act of 1 of 1850. So at a later stage, the scope of this legislation was expanded. The object of conforming the title to lands in Calcutta for public purposes, again for public purposes. so that they can carry out the developmental activities, its scope was widened. It was also that time when British were building railway lines across the country and needed some form of legislation which would enable them to acquire land for the same. So whenever they want to acquire land, they need to do it with a, you can say, uh, with authority, right? They cannot just take it. So they introduce the legislation so that they can acquire property and proceed with the construction of railway lines and connect the entire country. The Act of 42, okay, so this would be 42. The Act of 42 of 1850 declared that railways were public works and thus enable the provinces of the provisions of Resolution 1 of 1824 to be used for acquiring lands for the construction of railways. Likewise, similar acts were also being passed, like Bombay in Bombay in 1839. The Building Act and in Madras were also passed to facilitate land acquisition in these presidencies. So it was felt that we need to start with developmental works in this area, that area. Accordingly, the scope was widened. However, it was in 1857 that the British enacted legislation that applied to the rest of the provinces and presidencies, because they were focusing on one area only. So they introduced this legislation which applied in rest of the provinces or presidencies and the whole of British India. So it was just like how we have central legislations these days. Its scope was widened and it was made applicable to entire British India. Okay, so Act 6 of 1857 repealed all previous enactments relating to acquisition, and its object, as stated in its preamble, was to make better provision for acquisition of land, because we were having too many legislations, all scattered provisions. So it was thought that we will have one legislation, we will make better provisions for acquisition of land which are needed for public purposes within the territories in the possession of East India, like British India. Whatever territory comes, we will make a better law so that we can acquire property whatever is needed, and we can determine compensation based on the new provisions.
Okay.
This act, owing to unsatisfactory settlement, incompetence, corruption, was further amended. But still there were problems in this new legislation which was applicable in entire British India. So again, changes were made. And it was amended in 1861 and later on in 1863, and subsequently led to enactment of an act, Act 10 of 1870. Now, 1870 law, which for the first time brought a mechanism for settlement. Okay, for settlement, the reference to be a civil court for compensation if the collector could not settle the agreement. Settlement as in how much compensation should be paid to the parties, that settlement. Okay, was eventually replaced by the Land Acquisition Act of 1894. 1894 law did not apply to princely states like Hyderabad, Mysore, Travancore, which is like Kochi now, who enacted their own laws. So there were still places wherein their own laws used to be applicable. So this was what happened during British India. Because it is history, we have like too many legislations with too many years. Okay, so you can try to see how much you can remember. Like it's too many legislations anyways. So after independence, we adopted Land Acquisition Act of 1894. By the Indian independence, adoption of central laws, Central Acts and Ordinance Order 1948. So this Land Acquisition Act was introduced and it was adopted after India got independence. And this act allowed the government to acquire private land for public purposes, which could be used for large developmental projects like building of roads, industries, mining, public-private partnership projects, etc. For different public purposes, it could be acquired by the government. But the Congress government in 2013 passed this legislation, which we will be studying in Unit 1 and 2, that is Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act. This was passed to repeal this earlier legislation. Okay, so there was no transparency as such, right? If government wants to acquire, means they would simply acquire. Is it actually that it's needed, this plot of land is only needed? Is it actually that interest of public is superior as compared to interest of the residents there? All those assessment was not being done. Okay, is it actually a right decision to acquire the plot of land or not? That decision was not previously considered. It's just that simply in a rush land used to be acquired. So that problem this legislation wants to address. Okay, and the proper provision or like a proper procedure needs to be followed while acquiring land. The purpose behind introducing this act was to acquire land for strictly public welfare projects and to compensate the owners adequately. Okay, now you can put a conclusion that land is a precious resource for farmers and not anything less to any landlord, not just for farmers, even anybody who possesses a land, it's a valuable thing. It is the most important source of livelihood for the farmers. That's from where they earn their livelihood, who constitute almost half of the labor force in India. In India, majority people used to be in farming only, right, previously. So this is like very important that whenever land is acquired properly, it is being done. None of them wants to part with their land. The government has to carry out development work for which land is basic requirement. Like from both the sides, it's very important. Government also cannot stop developmental activities. And on the other side, for private persons also, it is important. So in 2013, this act was passed to ensure just and fair compensation, rehabilitation, and resettlement to the affected families. The effect of land acquisition on the affected families was to be guarded by a social impact assessment. So we will study about this as well at a later stage, which says that we need to assess, we need to see, calculate the impact that it will have on the society. That's nothing but social impact assessment. After that, only we need to take decisions regarding land acquisition, whether it's a proper decision or not, or how to carry out that decision. Not like in a rush, one day we will acquire it, how in a systematic manner we can do it. Okay, it also provided for the return of land to owners if it remained unutilized for a period of 5 years. Fine, you acquired the land, but after acquisition, are you actually constructing or doing the public public work or not? If not, if simply the land is lying there, after 5 years period, it can again move back to the owners or whoever was there previously. The determination of compensation was to be done under the method provided under this act. There are many more provisions which are landowners friendly, but there are certain flaws which, if removed, can make the act more just and acceptable. So this legislation mainly focuses on protecting interest of the ones whose land is being acquired. Okay, so they should not suffer. Based on that only, we have all the provisions and everything being mentioned. Okay, so that's like the present status what we have, and this is like the entire history how we reached this stage. Okay, is it clear?
Yeah, clear, ma'am.
I think it's too much information, right? For this question,
I
only
referred the note yesterday.
Sorry.
I got I referred the notes yesterday.
Okay.
So it is really helpful for me.
Oh, okay, fine.
To follow.
Actually, this question is like that, like too much information sort of a thing. Otherwise, this legislation is very simple and like common sense types of legislation. So this part only you need to like remember a bit. Okay, otherwise it's like, okay, what should usually happen when land is acquired? Like that only provisions are. So it is, yeah. So the first question you referred, is it yesterday?
Yes, ma'am.
Okay.